My name is Elaine Chu, and I'm a faculty member at St. John's University over in Queens County at the law school, but I'm also a very happy member of the planning committee for this year's joint conference. The first thing I want to say is you guys have been so cooperative. They would like to keep this area right in front of me clear because they're actually videoing this. I don't know why, who would want to see me speak. It's probably because of Janae. But if you could do that, that would be great. What a day today has been. Oh, that's right. We're going to have to wait on the food. What a day today's been. It's been such a fantastic opening for the joint 2017 CAPALF NEPOC conference. And I was reminiscing with Rose Vilazor earlier about how it was 6 very, very quick years ago that actually in 2011, for the first time, we did a joint CAPALF NEPOC. And so, and as it was then, it's also true today. It's already from the first panel I went to and watched, such an immediate kind of valuable thing to do these joint conferences. I felt that right away. So I want to personally thank the team here at Brooklyn Law School. We mentioned their names earlier, and also the planning committee for this joint conference. It's been really a fantastic experience working with so many committed, talented people. So I though wanted to start my job right now, which is to basically do a very brief introduction of Janae Nelson, the Associate Director Counsel of the NAACP Legal Defense and Educational Fund, and also the 2017 Kellis E. Parker Keynote for NEPOC. Now, the first thing I wanted to share with you is that Janae still returns my emails and phone calls. And that's despite her incredibly busy schedule and her very many responsibilities. Now, I'm certain that this is not because I'm anyone special, but rather because Janae is and has always been someone special. And the fact that she gives our relationship that time speaks to the kind of person that she is and has always been and will always be. And it's, of course, that character, those set of values that were at least part of the reason why, when she was one of us in the legal academy, so many of us admired her and called her friend. Now, there were, of course, other reasons, too, we admired her. She made and continues to make amazing contributions to the scholarship in informing election law, voting rights law, constitutional law. She had an amazing ability to produce within that ivory tower, but also to continue fighting the good fight on the ground. And she also has always had that savvy in kind of shaping the strategies and building momentum in these important civil rights movements of our time. Janae is a graduate from New York University and also the UCLA School of Law. She, from law school, went on to clerk for 2 years at the trial level and at the appellate level, as they all advise us to, the Northern District of Illinois, and then the 8th Circuit. And after her clerkship, she then went to work initially for LDF as their director of their political participation group. From there, I think at the tail end of that, she went to her first NEPOC, and I watched her on her panel. And she was amazing, of course. She then went on to do a 1-year stint as a Fulbright scholar with the Legal Resources Center in Ghana. And then she joined the faculty at St. John's Law. In 2017, she received the prestigious Derek A. Bell Award from the double ALS section of minority groups. She was also the Associate Dean of Faculty Scholarship at St. John's, before finally in 2014 returning back to LDF in her current capacity. Now, as LDF's Associate Director General, Janae, as I said, has many responsibilities, but I'm just going to share a few with you. She is on the media front lines for that organization and for their work. She makes so many frequent appearances on Now, I'm just going to give you a list of things like this year. Podcasts, such as the 451 podcast for resistance. She's participated on Slate's Amicus podcast with Dahlia Litwick. She's on mainstream television, CBS News, MSNBC. She has done radio with NPR's Brian Lehrer. I'm a big fan of his. She has posted regularly as a Huffington Post contributor. She is a very frequent, insightful user of Twitter. I know lots of Twitter fans are in here. And again, these are just some of the very many things she's just done in the couple of months of this year. Janae, in addition, is also in the courtroom making oral arguments. She's in conference rooms. She's on her laptop working on legal briefs and drafts. She's strategizing with her litigation teams at LDF. Last year, Janae was really busy preparing for an oral argument before the Fifth Circuit. It was the Fifth Circuit en banc argument in a voting rights case that ultimately struck down an intentionally discriminatory photo ID law that had newly passed in Texas. And in July last year, when the decision came down, again, with the victory for LDF and all of the organizations involved, we celebrated. Janae celebrated as we should have. And at that time, Janae, in the press release from LDF, said something that really caught my eye as I was preparing for today. She said, quote, "The critical election this November will proceed without Texas's racially discriminatory photo ID law casting a shadow on its integrity. This is an enormous victory for our democracy and an affirmation that the right to vote is fundamental and to be fiercely protected, especially against racial discrimination," end quote. So what is it now, 10 months later? An election with integrity, a fiercely protected fundamental right to vote for all Americans. Janae's statement from less than a year ago certainly rings in my ears, and right now, the concerns we had last summer seem so naive and incomplete. These days, when I find it hard to sleep or to read the news, I think sometimes about Janae, and I think about the good work that her team at LDF and the work of many other civil rights organizations are doing. And I also think about how she still returns my emails and phone calls, and how she is one of the best people we can all have on the front lines of the resistance movement. And then I smile. So my friends, please welcome the 2017 Kellis E. Parker Keynote, Janae Nelson.
Wow, that was some introduction. I am extremely grateful for Elaine for that warm and generous welcome, and for always being such a wonderful guide for me throughout this journey of academia, and just being an incredible sounding board, and clearly the best cheerleader any person could hope for. I really am so thankful. As many of you know, I was the Associate Director of the Ronald H. Brown Center at St. John's as well, and now Elaine leads that center. And that was a very difficult decision to know that a program and a center that I cared so much about would not be part of my regular life once I left LDF. But what gave me comfort is knowing that I left it in the hands of Elaine Chu, who is such a fierce leader and an amazing person and friend, and I'm just so incredibly grateful to you. So it's great to be here. I see so many familiar faces, and hi. And so many new faces, which is really delightful to see at NEPOC. And I really want to thank NEPOC and CAPALF for being the institutional leaders for faculty of color. We have so few spaces where we can share our scholarship and be uplifted and demonstrate our leadership. And these two institutions are incredibly important for all those reasons and more. And before I begin, I want to take a moment to congratulate Professor Peggy Cooper Davis, who is just amazing. I don't think she's in the room. I haven't seen her yet, but she is so deserving of the Hayward Burns Shannara Gilbert Award that she received earlier today. And she is such an inspiration to all of us who seek to enlighten and engage through the law. I also want to applaud tomorrow's recipients, who are also outstanding academics and servants of the law in their own right. So it's an honor and a privilege to give the Kellis Parker Keynote for a great many reasons, and not the least of which is because of Professor Parker's direct and unique ties to the Legal Defense Fund. As some of you may know, he clerked for Judge Spotswood Robinson, who was part of the legal team that litigated Brown versus Board of Education. And during Professor Parker's time at Columbia Law School, he also engaged with LDF regularly on a great number of cases. He was a model of a legal scholar in action. And that is a model that resonates very deeply with my own path in the law. And it resonates deeply with what I believe is a call to action for all of us in this challenging moment of truth in which we find ourselves. And this call to action is a simple one, relatively speaking, in the scheme of things, and yet it has the power to be transformative. And it is the call to speak, to do what comes naturally to law professors, to communicate and cut through noise and complex facts to unearth a vision, a strategy, a theory, to provide a way forward. That's what we aim to do both in the classroom and in our scholarship, and that aim could not be more privileged or more compelling than it is today. I am what you might call a boomerang, as you heard in some of Elaine's description of my career. I started practicing law, she said, as a fellow at LDF, and after a year in Ghana, looking at the intersectionality of law and democracy, I came to St. John's for 8 years and studied issues of race and ethics and election law, and then came back to LDF, a nearly 80-year-old African-American legacy institution of which I am extraordinarily proud. And there we are bringing civil rights cases and advancing just policies, and I have the privilege of working with the next generation of racial justice warriors. And I tell you this because I have zigged and zagged between academia and advocacy, not because I'm restless, but because I firmly believe in the law that there is some true symbiosis between practice and theory. Using the law effectively means understanding the law deeply. And to truly understand the law, you have to understand its effects on real people in society. Practitioners need to think like professors, and professors need to think like practitioners. This interplay between scholarship and advocacy, this call and response between academia and activism, to my mind, that is what makes the law, the vocation of the law, such a fulfilling one. And I've been fortunate to work throughout my career at institutions that really value the link between legal scholarship and practice. Scholarship has been central to LDF's work throughout our history. The most famous example of this, of course, is the studies from Mamie and Kenneth Clark in the Brown versus Board litigation, where they studied the effects of segregation on children, both black and white. Their research became commonly known as the doll test, that you all may be more familiar with. And that research helped lead to a victory in Brown versus Board that transformed our society, that ended at least lawful segregation in public schools, and that reverberated throughout our society. But that wasn't the only scholarship that was essential to transformative work at the Legal Defense Fund. Our work in bringing down racist housing covenants in cases like Heard v. Hodge, would not have been possible without a 1945 California Law Review article written by Professor Dudley McGovney. He was the first to provide a legal theory of why the state enforcement of racially motivated housing covenants was not just unfortunate, but unconstitutional. And our landmark victory in Grigg versus Duke Power Company, which established the adverse impact theory and dealt a severe blow to workplace discrimination. That case relied on a broad interpretation of Title VII that was developed by law professors at Columbia School of Law. So the lesson of these cases is clear. Transformative legal advocacy, and especially transformative civil rights litigation, requires transformative scholarship. And that lesson has perhaps never been more important for us to relearn than today. We are at a uniquely perilous moment in the history of our democracy, and I know I don't need to tell you that, but it can't be repeated enough. The election of the current president is a proven threat to civil rights and equal justice, the likes of which we haven't seen since Jim Crow. Just think of all that has been done and undone in the past 133 days. The president of our country issued an executive order that is effectively a ban on Muslim immigrants. What's more, he has sought to discredit the judges who have ruled that ban unconstitutional. The president of our country has empowered immigrations and customs enforcement to use racial profiling to aggressively arrest anyone on the barest suspicion that that target is an undocumented immigrant. The president of our country has established a commission on election integrity to investigate false claims of voter fraud in the 2016 election while ignoring indisputable truths of voter suppression against Black, Latino, and Asian voters. The president of our country has proposed a budget that targets the poorest Americans with malice, calling for severe cuts to federal aid in housing, education, and even food stamps, while he continues a unrelenting effort to strip away health care for the neediest among us. The president of our country has fired the FBI director who was overseeing the investigation into possible collusion between his campaign and a foreign government. He has called the press the enemy of the people. He has failed to recognize any connection between this administration's inflammatory rhetoric and the alarming uptick in hate crimes that has taken the lives of innocent human beings on account of their race, religion, gender identification, or the heroism to protect those freedoms. He has caused even the most conscientious and learned con law professors to reacquaint themselves with the Emoluments Clause. And our federal agencies have turned their back on civil rights and civil liberties as well. We now have a head of the Department of Justice who has openly demeaned consent decrees, wavered on longstanding positions in legal challenges like the Texas photo ID case, like the efforts to reform policing in Baltimore. Someone who has undone smart on crime guidelines designed to address the severe racial disparities in our criminal justice system. We have a Secretary of Education who last week said that she could not imagine a form of discrimination that a public school could engage in that would result in its losing federal funding under Title VI. And we have a Secretary of Housing and Urban Development who believes that poverty is a state of mind. I could go on and on. I really could go on and on. But that would only belabor the obvious conclusion. We are in uncharted waters when it comes to the rule of law in this modern era. And all that defines this multiracial democracy as a beacon of what is possible. To be clear, this is not about partisanship, not at all. This is about values. This is about the rule of law. It is about teaching the value of law to students in a moment when profound ignorance of history, hostility to the Constitution, and indifference to equal justice are celebrated in some of the highest echelons of power. It is not an exaggeration to call this situation a crisis of our commitment to our highest ideals, a crisis of our ability to care for one another as citizens, a crisis of our fidelity to the rule of law. And this crisis demands action from each of us, no matter who we are or what our role is. For those who are litigators, the realm of action is clear. It is the courtroom. And so far, the judiciary has been one of our best defenses against the most ruinous threats to our values and ideals. We have already seen federal courts invalidate a Muslim ban and take a strong stance against civil rights violations against LGBTQ Americans. And we are moving forward with policing reform despite the Department of Justice's dilatory tactics. So for advocates, it's clear what must be done. We must keep pushing ahead with litigation, with policy work at the state and local levels to defend the degradation of our Constitution, because it is working. It is working. But litigation is only one facet of the law. As I said earlier, scholars and academics together are vital to driving social change. This is in part why we created LDF's Thurgood Marshall Institute, to structuralize research and scholarship in our work. Sometimes scholars directly influence a judge's decision, as in the case of the Clarks and Brown or Professor McGovney's Law Review article, but that's not all that legal scholars do. We also change the framework of the national conversation, opening up the space where change can occur. That's what happened with Michelle Alexander's The New Jim Crow. It helped put mass incarceration on the national agenda. We exposed the blind spots, pointing out where we must broaden our perspectives in order to move forward. That's what happened when Cheryl Harris published White Privilege, Whiteness as Property, in the Harvard Law Review. It gave us a new lexicon for describing the concrete social and economic benefits conferred by whiteness. Sometimes you even change the understanding of history, like Annette Gordon Brown is doing in her writings about Thomas Jefferson and Sally Hemings, forcing us to confront the purposeful exclusion of people of color in the narrative of America's founding. The prolific writings of Robert Chang, likewise, have helped to illuminate a multidimensional narrative of Asian Americans in critical race theory, as did the scholarship of Richard Delgado for the Latinx community. And like the litany of assaults on our sensibilities and our senses since November 8th, I could easily go on and on about the ways in which legal scholars, and especially legal scholars of color then and now, and many of you in this room, have informed and shaped our collective consciousness about the law and its application to a uniquely diverse polity. This work is critically important, and the advocacy community, and indeed our country, needs all of us to advance it, not in spite of these perilous times, but because of them, in response to them. We need you to respond to this moment in your scholarship, in your pedagogy, in your service, in your own way. We need you. At a time when clear facts are subject to controversy, we need you to help reestablish rigorous standards of truth. We need you to reiterate the importance of equal protection and due process and the rule of law to our democracy. At a time when those in power would gladly undo the laws and policies that have brought us so far in the mere 60-odd years since American legal apartheid fell into demise. We need you to demonstrate why those protections still matter and why we need even more of them today. So whatever your area of specialty or expertise is, we need you to keep speaking up. That's the most important thing, not the form of your response, but the fact of your response. So in my darkest moments of late, I keep returning to Martin Luther King Jr. when he said, "We will have to repent in this generation, not merely for the bad words and actions of the bad people, but also for the appalling silence of the good people." For better or for worse, as law professors of color, we do not have the luxury of silence. We are required to communicate from the podium in the matters we take up in our clinics, in our scholarship, and in the quiet whispering of our mentoring. And we have the freedom to determine what we communicate to a new generation of change makers at a time when there's confusion and disillusionment, but also renewed passion and engagement. We must continue to push the envelope in research, to be creative, to forge new partnerships, to challenge students to take up the cause. Whatever we do, we cannot be silent. So lift your voices and occupy the octave that tenure provides. And it's a pretty high pitch. Call upon the better impulses of our national character so that one day, hopefully very soon, they may guide us to a fairer, better, and more just society. Thank you.